7-2. Pause on that number for a moment. 7 members of the United States Supreme Court delivered a ruling so far-reaching, so impactful, and so transformative that legal experts are still searching for the right way to describe it. While that debate continues, people across the country are already experiencing its effects. This is the story of an America thrown into turmoil following a powerful 7-2 Supreme Court decision. And if it seems like nothing more than another headline passing through the news cycle, a closer look is necessary. This is not routine politics. It is not another story destined to disappear by the end of the week. What took place inside the Marble Halls on First Street in Washington, D.C. carries implications that will remain long after every current office holder leaves government, long after today's media voices fall silent, and long after social media shifts its attention elsewhere. When the nation's highest court reaches a 7-2 outcome on an issue of this magnitude, it does more than resolve a dispute. It establishes a boundary and challenges everyone else to respond. At this moment, the country stands before that boundary, uncertain, frustrated, and searching for an honest explanation of what has occurred. The essential facts are straightforward. There is no political framing here, no partisan filter, and no attempt to soften the reality. The focus is simply on what this 7-2 ruling represents, how the situation developed, and what citizens need to understand before attention moves on to the next controversy. The first step is understanding what the court actually decided. Public discussion has become so tangled in legal terminology and political narratives that many Americans still lack a clear understanding of the decision itself. A 7-2 ruling from the Supreme Court is not a narrow or closely divided judgment. It sends a signal. When 7 of the 9 justices stand together, particularly on a matter involving the foundations of governmental authority, the court is communicating something larger than the immediate legal issue. The message is that the majority sees little uncertainty. The message is that the issue is considered resolved. The message is that the framework governing power has changed. According to the majority opinion, the court did not merely answer a legal question. It significantly broadened the reach of federal authority, altered the mechanisms through which accountability can operate, and expanded the degree of protection surrounding power before constitutional limits intervene. The justices forming the majority wrote with striking confidence. They brushed aside opposing arguments, portraying them not simply as incorrect legal reasoning, but as exaggerated warnings. Their opinion relied heavily on themes such as stability, order, and institutional consistency. Yet beneath that language was another message. It suggested that the court possesses a clearer understanding of the consequences of its decisions than the public does. History provides examples where similar assumptions have been made before. What makes this 7-2 ruling especially remarkable is the expansive reasoning behind it. Traditionally, courts often craft narrow decisions. They address only the issue necessary to resolve a case and avoid reaching further. That approach exists to preserve flexibility and recognize the limits of certainty. In this instance, the majority chose a different path. The opinion was broad. It was ambitious. It reflected the confidence of a majority aware of its strength and willing to exercise it. When courts write in that manner, the effects extend beyond the immediate dispute. The consequences move outward quickly and affect areas the justices may insist were never directly addressed. The 2 dissenting opinions deserve attention as well. They were not merely alternative legal interpretations. They were presented as cautions from jurists who viewed the decision as the beginning of a significant problem unfolding in slow motion. Their language was detailed and forceful. In a different media environment, those dissents might have dominated national discussion. Instead, they were often condensed into a few brief paragraphs before the conversation moved on. That reality says something about the state of American journalism in 2026. To understand why this ruling emerged as it did, it is necessary to examine the longer history behind the current court. A 7-2 majority does not appear by coincidence. Judicial majorities do not materialize on their own. The Supreme Court of 2026 reflects decades of political planning, Senate tactics, and, in some instances, institutional maneuvering that unfolded publicly, while many Americans had little ability to influence the outcome. Consider the developments of the previous 20 years. In 2016, a seat on the Supreme Court remained vacant for 10 months after Mitch McConnell declined to hold hearings for Merrick Garland, a moderate judge nominated by a sitting president who still had nearly a full year remaining in office. McConnell described that decision as a matter of principle. Critics viewed it differently. They saw it as a strategic exercise of power, and it achieved its intended result. Then in 2020, after earlier arguments that election year confirmations should not proceed, the Senate accelerated another confirmation process during the final weeks before a presidential election. No significant penalty followed. No major accountability arrived. The rules changed in public view, with cameras recording every step. Those responsible for those changes continue to be praised in some circles for their political skill. That history forms the backdrop for the 7-2 decision. When a court is shaped through procedural battles, when judicial confirmations become largely partisan contests, and when the idea of judicial independence is weakened until it survives mostly as a civics lesson phrase, the result can be a court reflecting the priorities of those who controlled the process at key moments rather than the full range of American legal thought. According to this argument, that is the institution that produced the 7-2 ruling. The justices themselves would likely say they are applying the law. They would point to constitutional text, historical evidence, and legal principles as the foundation of their decisions. Some undoubtedly believe that sincerely. However, confidence in personal impartiality is not necessarily the same as impartiality itself. The broader pattern of the court's decisions, the direction of its rulings, the cases it accepts, and the disputes it declines to hear all contribute to a larger narrative that mirrors the political circumstances surrounding its formation. No allegation of bad faith is required to recognize that institutional reality. As currently composed, the court leans in a particular direction. Americans experience the results of that direction whether they recognize it or not. The next question is what this 7-2 verdict means for ordinary citizens, not constitutional scholars, not television commentators, not political analysts with publishing contracts. What matters is how the consequences reach everyday people. The people most affected are often the ones least discussed. The individual working 2 jobs while caring for 3 children, the retiree trying to preserve benefits earned through 40 years of labor, the younger generation attempting to establish a future in a nation that can sometimes appear designed to benefit everyone except them. Those are the people who disappear from these debates. They are the individuals who ultimately live with the consequences of these rulings. When the Supreme Court alters the balance of power at the federal level, the impact rarely arrives in an obvious or immediate way. Instead, it moves through government agencies, state legislatures, corporate leadership offices, and regulatory systems that most Americans seldom consider until those systems weaken or vanish and serious consequences emerge. In this case, the 7-2 ruling significantly restricts the capacity of federal agencies to carry out regulations intended to safeguard workplace conditions, environmental well-being, financial stability, and the consumer protections that help prevent corporations from taking advantage of the public. Those protections are not erased in a single day. They do not need to be. What the ruling does is send a message to every industry subject to regulation throughout the country. It signals that enforcement mechanisms have become less powerful, that the legal landscape has changed, and that efforts to challenge regulations now stand a much greater chance of succeeding. That message spreads quickly. Consider the practical consequences. A company once discouraged from compromising safety standards because federal oversight carried real authority now reassesses the risks. A financial institution previously limited by agency supervision is now consulting attorneys to identify which regulations may be vulnerable. A pharmaceutical corporation, an energy producer, a telecommunications giant, all of them have effectively received the same communication from the Supreme Court. And that communication says the opening is wider today than it was before. Workers, consumers, patients, and citizens stand on the other side of that opening. This is not an imagined scenario. Historical patterns show what often occurs when judicial decisions steadily reduce regulatory authority. The country has seen similar developments before. Workplace injuries tend to increase in sectors where enforcement by OSHA becomes the subject of legal disputes. Environmental harm often grows in communities, frequently poorer communities, and frequently black and brown communities, when the EPA's authority becomes uncertain. Financial abuse affecting ordinary Americans can expand when protections designed to limit predatory conduct are weakened through unfavorable court rulings. The 7-2 decision changes more than legal doctrine. It changes power. And when power moves at the highest levels, those with the least influence often experience the consequences first and most intensely. Attention now turns to the 2 justices who opposed the ruling. Their dissents represented far more than simple disagreement. They wrote with a level of moral conviction and historical perspective that demands careful reading. Majority opinions carry legal authority. Dissents often carry something different. They can serve as direct statements of belief, free from the responsibility of preserving a coalition. The dissenting justices were not required to maintain unity within the majority. They were not obligated to soften language or conceal disagreements. Their task was simply to express what they believed. And what they expressed, in detailed and uncompromising language, was the view that the majority had taken a genuinely dangerous step for the nation. The dissents relied on historical references, established precedent, and rigorous legal analysis. They argued that the court exceeded what was necessary, reached beyond what the case required, and extended beyond what the Constitution demanded. According to those opinions, the majority embraced a concept of authority without a clearly defined endpoint. When a dissent essentially states that the destination of a legal theory cannot be identified, it is issuing a warning from individuals who have spent decades studying constitutional law and still cannot locate a limiting principle in the majority's reasoning. The emotional tone of those dissents was also notable. The legal arguments were powerful, but there was something more. There was sorrow, not hopelessness, not fragility. Rather, it was the grief experienced by people witnessing damage to an institution they had dedicated their professional lives to defending. They wrote about the court's legitimacy. They discussed the trust citizens place in institutions beyond their direct control. They examined the costs borne by real individuals when bold action is mistaken for sound judgment. Then they attached their names to those words and placed them into the permanent record of American legal history. They did so fully aware that the majority would proceed regardless. They understood that their warning might remain long after the immediate political controversy had faded. That was not performance, it was conviction. And in 2026, conviction within American institutions is uncommon enough to stand out when it appears. The dissenting justices also addressed something the majority declined to emphasize. They focused on people. They identified consequences. They described workers, neighborhoods, and families likely to experience the effects of the ruling. The majority discussed concepts such as authority, institutional structure, and the role of the judiciary. The dissent examined the practical impact on everyday American life. One side concentrated on legal doctrine. The other concentrated on justice. Only one of those positions secured 7 votes. There is another reality that must be considered. The Supreme Court did not arrive at this moment in isolation. The institutions expected to restrain excessive judicial authority, to serve as checks, counterbalances, and mechanisms of accountability, had already fallen short. And they did so repeatedly, publicly, and in ways visible to anyone paying close attention. Consider Congress. It is the branch possessing the clearest constitutional tools to influence the courts through legislation, constitutional amendments, judicial confirmations, and court reform. For years, however, it has either lacked the willingness or the ability to use those powers in a meaningful way. Responsibility exists across both political parties, although not in equal measure. The Senate's evolution into a battlefield centered on judicial confirmations, stripped of traditional norms, courtesy, and meaningful displays of independent judgment, occurred in full public view. The failure to enact significant ethics reforms for the Supreme Court also unfolded publicly. That happened despite documented concerns regarding conflicts of interest. It happened despite credible reports describing gifts and travel provided to justices by wealthy individuals whose interests appeared before the court. Congress observed an institution accumulating substantial power with limited oversight, and in the end, many lawmakers concluded that the political danger of confronting that institution was greater than the responsibility to act. That represents a profound breakdown of representative government. The 7-2 ruling stands as one result of that failure. There's also the role of the media. By 2026, the information system Americans depend on to understand public institutions has become deeply fragmented. News organizations that continue producing serious legal coverage reach only a small portion of the audience that needs to understand stories like this one. Meanwhile, the platforms capable of attracting enormous audiences show little interest in explaining the procedural foundations that allowed a 7-2 decision to emerge after 2 decades of Senate strategy. The subject is complex. It lacks dramatic visuals. It cannot easily be compressed into 60 seconds. As a result, it is frequently reduced to quick reactions, partisan narratives, and simplified arguments framed as what the left believes versus what the right believes, as if truth always exists exactly halfway between competing political positions. That is not always the case. At times, one position is correct while another is mistaken. At times, an institution has been intentionally altered, and the evidence supporting that conclusion is substantial. Responsible journalism identifies those realities clearly. According to this perspective, there's far less of that kind of journalism being produced than the nation currently requires. Political leadership bears responsibility as well. Leaders from both sides have often treated the court as a fundraising tool rather than approaching it as a matter of governance. Countless fundraising letters, digital donation requests, and political advertisements have invoked the Supreme Court not to educate citizens, but to generate alarm. The objective was not reform. The objective was often revenue generated through fear. People were warned that the court faced danger. Money was collected. The underlying issues remained unresolved. Now, a 7-2 ruling has arrived and the cycle is positioned to repeat itself. More messages, more fundraising, more political appeals. Without public pressure demanding structural change, the underlying system remains untouched. That raises an important question. Where does the country go from here? What should citizens do after a 7-2 Supreme Court ruling arrives and the nation appears unsettled while those in authority offer no clear path forward? The first response is refusing to treat the situation as ordinary. This is not ordinary. A court shaped through procedural maneuvering, issuing expansive decisions that alter power relationships, while generating dissents that read like expressions of constitutional mourning, should not be viewed as routine. Treating it as routine carries risks. Normalization leads to acceptance. Acceptance can eventually lead to the permanent establishment of a system that lacks meaningful accountability to the people it governs. That reality deserves careful consideration. Discuss it. Make sure people around you understand what occurred. Even when the subject is uncomfortable, even when the details are difficult, even when explaining it requires more than a minute, the next step involves accountability. Attention should focus on elected officials who possess authority regarding court reform and have chosen not to use it. Term limits for Supreme Court justices. Binding ethics standards for the court. Financial disclosure requirements that are fully transparent. These proposals are presented not as extreme measures, but as practical reforms supported by large segments of the public. According to this argument, political hesitation remains the primary obstacle. Citizens are encouraged to contact senators, to communicate with representatives, to attend town hall meetings, to demonstrate that electoral support depends on whether leaders are willing to address concerns about accountability within the court. Once politicians conclude that voters no longer care, the pressure fades and momentum for change disappears. There's another responsibility as well. Support the information systems that make accountability possible. That means backing journalism willing to perform the difficult and often uncelebrated work of explaining how power functions in reality. It means approaching information critically, regardless of political alignment, especially when complicated institutional problems are reduced to simple heroes and villains. It means encouraging media literacy within families, neighborhoods, and communities. It means bringing greater understanding into every discussion involving politics and government. A democratic system depends on an informed public. That is not merely a slogan, it is a historical reality. At this moment, the groups that benefit from public confusion possess greater funding, stronger organization, and more sophisticated strategies than ever before. The answer is not hopelessness. The answer is attention. Persistent attention, disciplined attention, relentless attention. Because the 7 justices who form the majority are relying on something familiar. Every concentration of power throughout American history has relied on it. The assumption is that people eventually become exhausted, that outrage fades, that the news cycle advances, that turmoil gradually transforms into a new normal that nobody consciously selected, yet everyone eventually accepts. Historically, that pattern often occurs, but it is not inevitable. The United States has faced similar moments before. There have been periods when courts, corporations, and political institutions appeared to establish arrangements benefiting power more than ordinary people. In those moments, resistance emerged. Not always rapidly, not always smoothly, not without sacrifice, not without years of organizing that sometimes appeared ineffective. Yet the resistance mattered. It produced results. It changed outcomes. The central question today is whether the people experiencing this moment possess the same capacity for sustained democratic participation shown by earlier generations when faced with comparable stakes. The belief expressed here is that they do. The alternative would mean accepting a nation in which 7 unelected justices can alter the fundamental structure of American life through a broad opinion issued on a Tuesday morning, while 2 dissenting justices place their warnings into the official record, and the majority proceeds regardless. It would mean accepting a situation in which the public simply observes events unfold and feels powerless to respond. That is not the country this moment calls for. It is not the country the dissenting justices were attempting to defend. The disorder many people feel following the 7-2 ruling is genuine. The frustration is understandable. The concern is real. Yet disorder is not destiny. Frustration is not surrender. Concern about the direction of governing institutions is not weakness. It is the beginning of awareness. And awareness, when sustained and focused, remains one of the strongest democratic tools available. The historical record is still being written. Future generations will remember where individuals stood when the 7-2 ruling was issued and the nation arrived at this turning point. As this chapter closes, the larger issue remains unresolved. The debate over accountability, institutional power, and democratic responsibility continues. The choices made from this point forward will determine how this moment is remembered and what follows in the years ahead. If the story resonates with you, continue the conversation, share your perspective, and encourage others to examine the facts for themselves. Public accountability begins when informed citizens remain engaged, ask questions, and refuse to look away from issues that shape the future of the country. Please leave your thoughts about this content in the comments below. Thanks for watching. See you in the next one.